Hi, everybody. I'm Brittany Lewis, a breaking news reporter here at Forbes. Joining me once again is First Amendment attorney Jeff Lewis. Jeff, thanks so much for joining me.
Yeah, thanks for having me.
The Supreme Court made some news this week when it announced it will not hear a case that would have asked the justices to overturn their decision on same-sex marriage. And I want to talk about how we got here. So first, let's go back to 2015, because then the Supreme Court ruled that same-sex marriage was legal in the United States. And 10 years later, so this past summer, a case was filed asking the court to overturn that landmark Obergefell ruling. So to start off the conversation, what is your reaction to the news?
You know, it's not a surprise because the case at issue here involving Kim Davis, who was a clerk involved in issuing or not issuing marriage licenses, this case had terrible facts. And whether you support gay marriage or you're somebody who opposes gay marriage, you want to have a case that will be precedent-setting, that will be of widespread application to many parties. And this case was very narrow. This particular person, Kim Davis, wanted to have a legal defense to a civil judgment that was entered against her. And it's not a surprise that cert was denied.
And so when you're an attorney and you're looking at these terrible facts in Kim Davis's case, what stuck out to you?
When I read the paperwork, the petition she filed and the briefs that were filed in the lower case, I was shocked at how narrowly she presented her issue. There are ways you can tee up the religious freedom issues versus the dollars at issue in terms of the civil judgment, but instead she went for a very narrow attack. I think that was a tactical mistake by her lawyers.
And do you think that if she kind of widened that, do you think that if it wasn't so narrow, it would have had a better shot here?
Perhaps, although the optics of this case aren't great. She is a public official who acted in open defiance of Supreme Court precedent. It's not great optics for somebody, let's just say there's a Supreme Court justice who wanted to strike down gay marriage and overrule Obergefell. This is not a great face for that kind of case.
And I want to talk about that face to begin with. If we all can remember Kim Davis, as you said, she was that former county clerk in Kentucky. She briefly wound up in jail in 2015 after she refused to issue same-sex couples marriage certificates after the Obergefell ruling. So since the Supreme Court rejected her petition here, is this the end of the road for her legal fight?
It is, at least for this legal fight, in terms of this civil judgment. It will stand. She's exhausted all her appeals, and she's going to have to pay that judgment. That's not to say she won't file a new lawsuit in the future, but this case is over.
And I want to talk about what this means then for this landmark ruling, because back in 2022, this is what had LGBTQ advocates so scared. In a concurring opinion on the Dobbs case, Justice Clarence Thomas said that the court should reconsider Obergefell since both rulings are based on the same legal argument. But a 6-3 conservative court refused to revisit overturning their same-sex marriage ruling. So does this mean finally that this is settled?
Absolutely not. All it means is there weren't 4 votes. There were not 4 justices who believed that this was the right case to attack the sanctity of gay marriage. I expect more direct attacks on gay marriage to be mounted in future lawsuits and in cases that have better optics and less of a history in front of the Supreme Court.
That absolutely not sounded very certain. I mean, and I know you said Kim Davis's legal case had a very narrow scope. I mean, do you think then that's going to give other people incentive to maybe widen that and present these cases in front of the Supreme Court?
Absolutely. You can expect that parties who are more directly going to challenge Obergefell and the concept of legal gay marriage, not in the context of trying to defend a civil judgment, but a more frontal attack, those kinds of petitions will be presented to the U.S. Supreme Court. And then the real question will be, are there institutionalists on the Supreme Court who don't want to overturn relatively recent precedent? Or are there enough people who feel so passionately on the Supreme Court about this issue that they're willing to overturn recent precedent?
What do you think, based on the court now, 6-3 conservative court, do you think that they would be willing to make that move?
I think there are enough justices on the Supreme Court that if better facts were presented with broader legal theories, they would absolutely agree to hear the case. I don't know whether or not there's enough votes to overturn Obergefell.
I know that you answered absolutely not when I asked you if this meant that same-sex marriage is finally settled now, but because the court decided not to hear this case, does this indicate anything to you, especially because the court is a 6-3 conservative court? Does this indicate anything to you about where they're at right now?
Not really, other than, as I said before, that there were not 4 votes who thought this was a good case for revisiting this issue.
And President Biden, back in 2022, he signed the Respect for Marriage Act, and this legislation requires all states to recognize same-sex marriages if they were performed legally in a state where same-sex marriage is allowed. So even if the Supreme Court eventually one day reverses Obergefell, is that enough of a legal safeguard, in your opinion?
It is for people who live in states that respect gay marriage, meaning if you obtained a license in a state that issued it to you, you can't be stripped of that license. So that is a safeguard. But if you are a person who lives in a state that forbids gay marriage, that legal doctrine is not going to be much comfort to you.
And I know that the Supreme Court doesn't hear most of the cases it's asked to hear. It rejects most of them. But what specifically are you looking out for next? And did anything surprise you about this right now?
Well, the Supreme Court typically looks for 2 things. One, a split in the circuit. So if some courts in parts of the United States are deciding issues one way and other courts are resolving these kinds of cases in another way, they look to resolve those splits and settle these questions. Or if there's an important enough constitutional question in terms of where we are in the country and the time is right to take up the case, that's the kind of thing that the Supreme Court looks for in accepting cases. I would expect to see similar petitions being filed with the Supreme Court, not in the context of civil judgments, but more directly attacking whether or not gay marriage laws or laws that allow for licenses to be issued are permitted under the Constitution.
And nationally, according to polls, it doesn't seem like there's much appetite when it comes to overturning Obergefell, when it comes to making gay marriage illegal. Do you think that the time would ever come where the Supreme Court would say, you know, optics might have swung the other way here. Now's the time to take this up?
Yeah, that could happen, but the interesting thing here, as you've laid out during this interview, is one, you have the Respect for Marriage Act with other states having to respect the rules and holdings of other states. That's very unique. That wasn't applicable, let's say, in the Dobbs case. And plus, you have a lot of people who've obtained these licenses who are married, who have this substantial vested interest in being married. I don't know the Supreme Court will ever have the appetite to strip those people of those rights.
Well, Jeff, thank you so much for your legal expertise here, for breaking it down. You're welcome back anytime.
Thanks for having me.